Thank you for being here. We're here on CV140193. It's Laughlin versus Lords. Each side will have 20 minutes to do your argument. Appellant, you'll have 20 minutes to speak, and if you want to reserve any time for rebuttal, you're free to do that. You'll have to keep track of that on your own. There's a clock at the podium for that purpose. We are recording the argument today both in video and in audio. The video will be on YouTube in a day or two, so you can look to and watch how you did. We've conferenced the case. We've read the briefs. We're familiar with the case, so just launch right into your argument. And because we're recording the argument, please identify yourself and your client when you begin your argument. Counsel, you may begin.
Thank you, Your Honor. May it please the Court. The first issue I want to address is a very fundamental issue that I think was often overlooked underneath, and that is that there are three separate entities opposite David Lords in this case. There's Consolidated Mortgage, the initial plaintiff. There are the group of investors that Consolidated Mortgage acted on behalf of when it filed the complaint. And then there's a third, independent, legally separate entity, Laughlin Land.
Well, Counsel, the real party in interest here, as I understand it, are the 93 investors. And at the beginning, they operated through their an agency MO, and then at some point that got switched to a new agent. But the 93 investors are the real parties in interest, so I don't really understand the problem, and I'm not sure what's gained here.
I agree that the real parties in interest are the 93 or 86. The numbers kind of changed a little bit, but it's a number of investors that funded the loans that Lords guaranteed. And they initially were represented or acted through Consolidated Mortgage. And then they subsequently were, Laughlin Land came in. But what didn't happen was there was never any evidence of any assignment or delegation of the individual's right to pursue that guarantee to Laughlin Land. Now,
what about the organic documents of Laughlin itself? I mean, doesn't Laughlin, by virtue of its creation and its membership, demonstrate the investors' desire that Laughlin hold those interests and proceed as a matter of procedural convenience?
No, Your Honor, I don't think it does. And a couple of the reasons, the operating agreement, that's the controlling document creating Laughlin Land and controlling what Laughlin Land can do. That document was not signed by any of the investors. And that document, I think that's a very important issue there because...
Do you think the investors are indispensable parties?
They're indispensable parties, or they need to, or Laughlin Land needs to show how it obtained the right to sue.
Why not just file a motion to join them as indispensable parties? I mean, it doesn't seem to me that the result is dismissal. If what you're worried about is some theoretical risk of multiple liabilities, then why not just use Rule 19 and join them?
Well, I think the fact that they were substituted out, the case, that's not the way the case was presented. The case was presented to us now after amendment that it was Laughlin Land suing, and Laughlin Land has this burden to show how it has the right to sue under this guarantee.
Well, if it didn't have that right, don't you think some of the investors would have come in and screamed bloody murder and say, who's this stranger taking our cause of action?
They may very well have done that, but I mean, and no, I don't think anything like that has happened. But
So is this a purely academic argument then, that Laughlin didn't take care of its own house well enough to be a plaintiff? I mean, it seems to me the question is whether your client owes anything, and if so, how much, not how Laughlin takes care of its own business.
well, and I think an analogy is helpful here in a common situation with an estate plan and a trust. People create a trust all the time. People fail to fund that trust. That renders the trust worthless. It's just an empty bucket. And that's really what happened here. Laughlin Land got created, but they didn't fund it with the right to sue under the guarantee. They funded it when they executed the quitclaim deed, assigning the trust property after foreclosure to Laughlin Land, but they never just did the simple act of assigning the guarantee.
Well, but they're acting on behalf of the 93 or 86 investors. Isn't that enough? I mean, they're not suing in and for themselves. They're suing on behalf of the 93 investors. And if there's a technical problem, under Rule 17 can't, a proper substitution be made, and then everything is fine, and then we can move on, as Judge Swan said, to the real issue is, how much money is owed.
Well, and I mean, the operating agreement was executed, again, not by any of the investors, but it was executed by Consolidated as manager of Laughlin Land. And it was
But
executed.
they did that. They did that in aid of the 93 investors.
Well, actually, it was the manager of Laughlin Land. I mean, they weren't doing this gratuitously. I mean, yes, that's who they were working for. But that creation of Laughlin Land occurred prior to the foreclosure, the trustee's sale, and prior to the initial complaint being brought. If the right to sue under the guarantee was divested from Consolidated, then Consolidated did not have the right to bring the suit. And then when Laughlin Land brings this amended complaint 3.5 years later in September of 2011, they wanted to relate back to April of 2008, but Consolidated didn't have the right to sue at that time, admittedly, because it had assigned it or
Who does your
conveyed it.
client want to pay on the guarantee?
Consolidated for the benefit of the investors. That's the party to the guarantee that he signed.
So you'd have no objection if it were Consolidated suing?
No, we don't dispute Consolidated for benefit of the investors has standing, but
Okay, and Consolidated has a right in its organic documents to create special purpose entities to handle various aspects of the transaction. It did so. Why is it your client's right to object to the way it decides to do business?
it does have the right in that I think there's a loan servicing agreement. I think there's a special power of attorney to create this special purpose entity. But again, that's like creating this vessel. You need to fund the vessel. And that's what they failed to do.
This sounds like the argument that so often was made against MERS for years that we've routinely rejected.
The show me the note argument you're alluding to here, I believe.
The question is whether there's a liability. Not one of the real parties in interest is here objecting to Laughlin. That ought to tell us something, shouldn't it?
Well,
if your client pays Laughlin, and then somebody comes out of the woodwork and says, "Hey, wait, this was my cause of action," you'd have a pretty powerful argument at that point. But I think selecting your plaintiff is it's detracting from the discussion of the merits.
well, I think one applicable law that was overlooked below and shouldn't be overlooked here is that this is a deficiency action on a personal guarantee. Personal guarantees, as a matter of law, need to be construed, strictly construed, in favor of limiting liability of the guarantor. Without this assignment, the trial court assumed or inferred the assignment for Laughlin Land.
But this doesn't expand your client's liability one iota. If your client is liable to Laughlin or ABC Corporation or whatever it may be, it's no more liable because of these changes in name or nominations of parties to serve as agents. The question of the extent of your client's liability, I think, is probably something we ought to discuss.
Your Honor, and I agree that this doesn't expand Lord's liability, but I believe it's the Cushman case that I cite to, is that the guarantees must strictly be construed to limit the guarantor's liability, so that the trial court cannot take steps to aid or assist that liability. And that's what happened here without any evidence of a real assignment.
Expand? Isn't
Yes.
This, okay. And if it doesn't expand, then it's really not running afoul of any limiting principles.
I think that it's still the court is inferring a guarantee where none was assigned. It's inferring assignment where there is none.
Well, but all we're talking about really is proper pleading, it seems to me, and under Rule 17, every case, must be brought in the name of the real party in interest, and if there's a problem, then a proper substitution can be made. So I don't really see a substantive problem.
And that's a correct statement of law, but there's one additional element that's cited in our brief, is that the substituting party still has the burden to prove that it has standing to sue on whatever that cause of action is, in this case, a breach of contract under the personal guarantee. And that's where Laughlin Land fails, because it can't prove that it has standing under the guarantee because there's no assignment. A quitclaim deed conveys property. It doesn't assign a contractual right.
Why don't you move on to the merits?
Let's do the value
Yes,
issues.
please.
Yes, Your Honor, Your Honors, I'll do that. And let me grab my separate note for that. And the first issue of value is the amount of the indebtedness that the trial court found at the time of the trustee sale, the first factor in calculated deficiency. It based that amount on something greater than the amount of Laughlin Land's proof of claim in the bankruptcy case. Again, when you strictly interpret the language of the guarantee, Lords only offered or contracted to guarantee whatever amount that Lure, the initial lender, was obligated to owe. That amount was set in its bankruptcy at, I believe it was just over $18 million. The trial court instead found that Lords owed approximately $22 million, additional amounts accruing above and beyond that amount. Again, when you take a look at that guarantee, you need to look at the specific language, and that language does not allow this expansive amount that is guaranteed. He's only guaranteed what they owed. Yes, they didn't pay that. I don't believe Lure ended up paying anything in its bankruptcy, but they can't. Lords is not liable for any amounts above what Lure was obligated to pay, and that was error by the trial court.
It's an attractive formulation, but just help me here for a moment. After the bankruptcy, Lure owes nothing. So does that mean the guarantee is worthless?
Well, Lure is calculated to owe a certain amount, and that's the amount Lords guaranteed. So Lords owes that amount.
But after the bankruptcy, Lure doesn't owe that amount. So could your client then take the next step in this argument and say, well, my liability is coextensive with that of the borrower, and the borrower has been essentially discharged from this debt, so I'll ride that horse.
Well, and we're not making that argument, and I don't think we can make that argument because
I agree, but I'm using it as sort of an absurd hypothetical to see just how far the literal language of the argument you are making goes, and whether there might be a flaw in that argument.
Well, and I don't think there is, though, again, because you have to construe the language of that guarantee strictly to limit the liability of the guarantor.
Mm-hmm.
The law, it frowns upon these personal guarantees. That legal principle that you strictly construe them in favor of the guarantor, combined with the fact that this is a deficiency action. I mean, the legislature has said you need to bring this deficiency action within 90 days of the trustee sale. That's a strict statute of repose, and that evidence is the legislature's idea that we don't want these deficiency actions dragging on for 6 years like a normal contract claim. That combined with the strict interpretation of a guarantee, when you look at the language of the guarantee at issue here, it strictly says, I'll pay whatever it's determined that Lure should have paid. And then that amount was the $18 million number, not the $22 million.
Well, what Lure should have paid is the note. I mean, Lure should have just complied with its contractual obligations. It failed to do so. What's the best case for the proposition that the bankruptcy filing stops the accrual of interest for a guarantor? Because that's really your argument, right? Once the Lure sought bankruptcy protection, interest no longer accrued as against Lure, and therefore it no longer accrued as against the guarantor.
And that's the express language in the guarantee. It's that ILords will pay whatever it's determined that Lure has to pay. In
the event of bankruptcy.
Yes.
Okay.
Even in the event of bankruptcy.
And is there a case that happened to consider that structure?
I believe we do cite cases, not necessarily specific to that structure, but for the more general proposition.
You cite cases, yeah, but and they are generally in accord with the view you're expressing. But I'm just wondering if you've got anything that dealt with this transactional structure that makes the bankruptcy filing date the date that all interest stops accruing for the guarantor.
No, I'm not aware of any cases specific analogous to this situation. And so that's that first factor in calculating the deficiency. And the second factor is going to be the value of the trust property at the time of the trustee's sale. Both parties put on experts that opined as to what that value was. And that was the only evidence put on of what the value of the property was. The plaintiff's expert, appellee's expert, opined, I believe, that it was approximately $9 million was the value of it. And Lord's expert opined that it was, I believe it was approximately $19 million or $18.5 million. The court expressly stated, the trial court expressly stated that it didn't agree, it wasn't buying Laughlin Land's expert's appraisal. It shot it down completely, which leaves the only other evidence out there for the court to adopt is Lord's expert.
Well, but counsel, the court isn't bound to pick one or the other. It can look at all of the evidence and decide for itself what it deems the fair market value is, correct?
As long as it does so on a reasonable basis. And I understand my burden here is very high, that I'm saying this is an abuse of discretion for the court to adopt what was this in-between number. But the only evidence of this in-between number was this other appraisal from a different period in time. And property values were changing rapidly at that time, as I think that was acknowledged by Lord's expert, and I believe the court also acknowledged that. So it was patently unreasonable for the court to just ignore both, and while expressly disavowing Laughlin Land's expert, and just pick this other number that was done at some different period of time. So the calculation should be very different. It should be the $18 million number, and then when you look at the actual value of the property, there is no deficiency.
But that just sounds like, it sounds like what you're arguing is that the trial court was stuck with either expert's opinion. It couldn't decide somewhere in between.
And I don't mean to say that, but it can get somewhere in between, but it has to have a rational, reasonable basis to do so. And pulling this other opinion that the court relied upon, we look at the transcript from the trial, it pulled another appraisal that was done by another non-party that was done well before the trustee's sale.
But
And
doesn't the
it's-
court have a rational, reasonable basis to assign value once there's any evidence in the record as to value? The court can't come up with a value if there's no evidence talking about value, but once the parties have introduced some appraisals and any type of evidence, the court can pick and choose amongst that evidence to decide what the precise value is in the eyes of the court.
Well, and if it was entered into evidence, but the appraisers used other appraisals to formulate their opinion, but I don't believe that's technically evidence for the court to consider. That's something that they can consider, and, they're not subject to the same rules of admissibility that the trier of fact is concerned with. The fact that the court just chose this other number was unreasonable. It was an abuse of its discretion to pick that number when the only other number of evidence that it did not disavow was Lord's expert number of approximately 18.5 or 19 million. Your Honor, I have 26 seconds left. I'd like to just reserve whatever I can to respond
Thank
to
you, of
Mr.
course.
Hastwick's arguments. Thank you.
Oh, please, of course.
May I please the court? My name is Andrew H. Pasek. I represent Laughlin Land. There are three issues today that Mr. Lords is appealing. First is whether or not my client had standing. The second issue is whether or not the bankruptcy court could, I apologize, whether the court could assess post-interest bankruptcy interest to the judgment. And the third claim is whether the appraisal, whether the court properly considered both appraisals. Our position is the trial court got all three decisions right. In order to determine whether Laughlin Land had proper standing in this dispute, it is necessary to discuss the facts of this matter. While both parties agree about the facts, there's a dispute as to what the facts actually represent. The appellant has argued that there is an assignment case and that the issue is to determine what did Consolidate assign its interest to Laughlin Land. However, this representation is incorrect and flawed. This dispute is more complex than just determining the specific date of the assignment. In 2006, Consolidated solicited investors to invest money into a commercial real estate market. Consolidated intended to have the investors provide them with money, and then Consolidated would make loans using this money. Consolidated would then service a loan and would be responsible for foreclosing on it in the event the debtor defaulted on the loan. One of the projects Consolidated solicited for was a property in Bullhead City that Laura wanted to purchase.
We're familiar with that background. Maybe I could ask you to spend a little time up front on issue number 2, on the post-bankruptcy interest accrual.
Correct. The cases I've reviewed, having practiced in bankruptcy, just because the guarantee filed for bankruptcy, that does not prohibit interest from accruing on the loan.
No, but isn't the guarantee liability in this case, well, in every case, based on the language of the guarantee itself?
Correct. And in this, if you look at the guarantor, there's no specific language. If you look at the guarantee agreement, there's no explicit language saying, hey, once the person files for bankruptcy, all interest stops.
No, all interest doesn't stop on the loan, but isn't there language that says that the guarantor's liability is coextensive with that of the borrower?
Like some guarantees can make the liability for the guarantor independent of the principal obligor. They're responsible on the full value, no matter what the original party owes on it. But this one is linked to what was owed.
Correct.
Right?
Correct, but the agreement is silent on what happens if the party files for bankruptcy. Let's take this hypothetical. Let's say he files for bankruptcy, and according to his argument, that the interest is stayed. What if the bankruptcy is dismissed? Does the interest suddenly start accruing again, or is there a gap?
Bankruptcy is dismissed, and the borrower is on the hook for the whole amount, right?
Correct.
But here the bankruptcy wasn't dismissed.
Correct.
You're not allowed to give us hypotheticals. That's a joke.
I was playing it out to the extent that,
Well, I found it a helpful hypothetical, unlike Judge Gould, apparently.
I apologize,
No,
Your Honor.
I found it a helpful hypothetical, and it leads me to really the same point. Isn't it the case under this guarantee that whatever the borrower ultimately wound up owing is the guarantor's responsibility if the borrower doesn't pay? Here, we found out what the borrower ultimately owned because of bankruptcy law, which is largely untethered to equity, right? I mean, equity would say pay what you owe, but here there was a determination as to what was owed. The borrower didn't pay it, so now the guarantor has to pay it, but the guarantor doesn't have to pay more than the borrower would have under this language as I read it. If I'm reading it wrong, this is the time.
well, my position would be the interest would continually accrue.
I'm sorry?
My position is that the interest would continually accrue.
But then the guarantor would owe more than the borrower.
Correct, but there's no limit, if you read the guarantor agreement, there is no limit saying if they file for bankruptcy, all interest stops.
One second. Unfortunately, I don't have the language in front of me, but do you have the guarantee in front of you?
Your Honor, may I approach? I do have it with me.
Oh, you don't have
No,
to.
no, please, can you read,
Yeah, if
can you
you've-
read the pertinent language?
If you've got the pertinent language, I'd love to hear it.
Your Honors, I do apologize, but the copy I have is very bad language. I can't read it. It's
You can use bad language here.
it's ineligible. It's unreadable.
Is it?
It's
Okay.
so small. And the only reason I read it yesterday in preparing for this is I had to blow up the 500% on the printer, and I specifically looked for what language cites it says once the individual files for bankruptcy, all of the interest stops.
Yeah, I think everybody would agree that it's silent as to the word bankruptcy, but as I recall, it did use some language to the effect of the guarantor will be liable to the extent that the borrower is liable. And if that's the case, and we are supposed to construe guarantees narrowly, and there's nothing in the guarantee to suggest that the guarantor's liability can exceed that of the borrower, I don't see how the trial court got there.
Answer for you, but the cases I did cite in my brief specifically say that they considered a guarantor issues similar to this, saying yes, the court can assess post-petition interest to a judgment.
Okay. Thanks.
The other issue is the appraisal. There was both parties gave appraisers. This trial was actually 2 days, and the majority of the 2 days was spent on these appraisers. One side had, I believe, our appraiser said the property is worth $12,800. Their appraiser came back and saying the property was at $20,000, and the court actually found more in their favor than in my client's favor, and determined that the property was at $18 million. I don't, under the court's decision under Loop 101, I don't see any grounds for reversing the trial court's decision that the property was worth $18 million. The court considered all the evidence, read all the her testimony, looked at all the evidence, and came up with this figure on their own.
I tend to agree with you that it's kind of hard to find clear error on this record. But are you suggesting that the rule is, as long as the court goes somewhere in between two estimates, it's per se an affirm?
Well, the opinion from Loop 101 said the court consider the highs and lows and take a number in between. In this case, the market was fluctuating when the foreclosure occurred. And so and these estimates are, one's very high, one's very low, and the court kind of went in the middle.
Could the court have gone below your expert's appraisal number and still been exercising or been within its discretion?
Under the decision in Loop 101, I would have argued no. The court.
You overturn Loop 101? Judge Howe wrote that, so I want to know if you think we should.
I like that. I like the decision because you take the high and the low, and you have discretion. In this case, the court had a discretion of almost $8 million.
But the judge could have disregarded a component of that lower appraisal and still have been acting within his discretion, right?
I would have said no, Judge.
What if there was nuclear waste on the property and the appraisers said, it's not that big a deal? So that the judge felt that the high and low were both too high. And the judge thought that nuclear waste on a property was a significant enough detriment to merchantability that it was going to assign a value of $1 to a nuclear waste dump.
Well, under your hypo, there would have been testimony that there was nuclear waste on this property.
I'm assuming that.
Is this a helpful hypothetical?
It's a hypo. It's not a helpful hypo. It's not a helpful hypo, but it's a hypo nonetheless, and I'll answer it. Let's say there was a testimony during this trial that there was nuclear waste on this property, and the judge just said, hey, it was worth $1, and if the court would have put that in the minutes, in the order that I found nuclear waste, the property's only worth $1, that probably would have been sufficient under Loop 101, because the court gave a reason why it found the property to be only worth $1.
But if it doesn't give any reason and it falls in between two estimates, your read of Loop 101 is that's good enough.
Correct, Your Honor.
I'll have to ask Judge Howe, but okay.
Your Honors, in conclusion, we would respectfully request that you uphold the decision of the trial court. Unless you have any questions, I'll sit down.
Thank you, counsel. And counsel, we asked you quite a lot of questions, so we'll give you 2 minutes if you need for rebuttal.
Thank you, Your Honor. The first thing I'll do is I'll just answer the court's question about the language in the guarantee. In the guarantee, Lord's guarantee to pay, quote, the indebtedness of borrower to lender. And that term indebtedness is later on defined. I actually block quoted in page 50 of the opening brief. I think it's the easiest version to read, but it's also in
That's where I read it, actually, but I'm trying to recall the limiting language, because one could easily say that the indebtedness of the borrower is equal to performance of the obligations it undertook.
And that's not the language in the defined term.
What's the best limiting language you got?
The borrower individually or collectively or interchangeably with others owes or will owe lender. And that amount was set in the bankruptcy at the $18.414 million number, a significant departure from the $22 million number.
So you're basically using some form of collateral estoppel to say that all it owes is what the bankruptcy court determined.
Because that's what Lords contracted to guarantee. And when you strictly construe that guarantee as the law requires, that's all they contracted for. They could have written a different guarantee. Lords probably would have signed it, but that's the guarantee that he signed, limiting his liability to the indebtedness of Lord, the borrower there. So page 50, it's also tab 3 in the appendix that we provided to the court. It's one of the exhibits behind there. And to summarize, I mean, we still take issue with Laughlin-Land's standing, and I think we've gone through that. But this amount of the amount owed at the time of the trustee's sale, when you look at the language of that guarantee and the term indebtedness, does limit it to amount significantly less, reducing the deficiency balance from approximately $4 million to about $400,000 if the court is inclined to only reverse on that issue. We still think it should reverse on all the issues and find that Laughlin-Land failed to prove that it has standing for the note, but in any event, the guarantee only made Lords liable for that amount of indebtedness as it's used in the guarantee.
Thank you, counsel. Thank you for your argument. We'll take this matter under advisement and issue a decision in due course. We stand at recess.